Good day, Canada. Alex Monahan here, Foundations Party, ineligible. Today's date is April 20th, 2017. And we are going to continue reviewing the Immigration Protection Refugee Act. And we are going to pick up where we left off of the last part, the second part of Part 8, or the last half of Part 8, excuse me. And that'll be designated countries of origin. Paragraph 109.1, subparagraph 1. The minister may, by order, designate a country for the purposes of sections 110.2 and sections 11.1. Limitations. So paragraph 2. The minister may not only make a designation, A, in the case where the number of claims of refugee protections made in Canada by nationals of the country in question, in respects of which the Refugee Protection Division has made a final determination, is equal to or greater than the number provided for by order of the minister. 1. If the rate exceeds as a percentage that is obtained by dividing the total number of claims made by nationals of the country in question, that in a final determination by the division during the period provided for in the order are rejected or determined to be withdrawn or abandoned by the total number for claims made by nationals of the country in question, in respects of which the division has during the same period made a final determination, is equal to or greater than the percentage provided for in the order. Or 2, if the rate expressed as a percentage that is obtained by dividing the total number of claims made by the nationals of the country in question, that in a final determination by the divisions during the period provided for the order are determined to be withdrawn or abandoned by the total number of claims made by the nationals or of the country in question, in respects of which the division has during the same period made a final determination, is equal to or greater than the percentage provided for in the order or B, in cases where the number of claims of refugee protection made in Canada by nationals of the country in question, in respects of which the Refugee Protection Division has made a final determination, is less than the number provided for by order of the minister, if the minister is of the opinion that in the country in question, 1, there is an independent justice system, 2, basic democratic rights and freedoms are recognized and mechanisms of readiness are available if those rights and freedoms are inferred, and 3, civil society organized exists. If that exists in my country. Anyway, moving on. Order of minister. So paragraph 3, the minister may, by order, provide for the number per period of percentage referred to in section 2, subsection 2, Statutory Instruments Act, subparagraph 4. An order made under subsection 1 or 3 is not a statutory instrument for the purposes of the Statutory Instruments Act. However, it must be published in the Canadian Gazette. Appeal to Refugee Appeal Division. Appeal. Paragraph 110, subparagraph 1. The subject of subsection 1.1 and 2, a person or the minister may appeal in accordance with the rules of the board, on a question of law, of fact, or of mixed law and fact, to the Refugee Appeal Division against a decision of the Refugee Protection Division to allow or reject the person's claim of refugee protection. Notice of Appeal 1.1. The minister may satisfy any requirements respecting the manner in which an appeal is filed and preferred perfected by submitting a notice of appeal and any supporting documents. Restrictions on appeal, subparagraph 2. No appeal may be made in respects of any of the following. A decision of the Refugee Protection Division allowing or rejecting the claim of refugee protection of a designated foreign national. B a determination that a refugee protection claim has been withdrawn or abandoned. C a decision of the Refugee Protection Division requiring a claim for refugee protection that states that the claim has no credible bias or is manifestly unfounded. D. Subject to the regulations, a decision for the Refugee Protection Division in respects of a claim of refugee protection if 1. The foreign national who makes a claim directly or indirectly to Canada from a country that is on a day on which the claim is made, designated by regulations made under subsection 102.1, and that is a part to an agreement referred to in paragraph 102, subsection 2D, and 3, the claim by virtue of regulations made under paragraphs 102.1c is not ineligible under paragraphs 101.1e to be referred to the Refugee Protection Division. D1. A decision of the Refugee Protection Division allowing or rejecting a claim of refugee protection may be made by a foreign national who is a national of a country that was, on the day on the decision was made, a country designated under subsection 109.1, subparagraph 1. E. A decision of the Refugee Protection Division allowing or rejecting any applications by the minister of a determination that refugee protection has ceased. F. A decision of the Refugee Protection Division allowing or rejecting an application by the minister can vacate a decision to allow a claim of refugee protection. Making of appeal 2.1. The appeal must be filled and perfected within the time limits set out in regulations. procedure. Subparagraph 3, subject to subsection 3.1, 4, and 6, the Refugee Appeal Division must proceed without a hearing on the basis of the record of the proceeding of the Refugee Protection Division and may accept documents, evidence, and written submissions from the minister and the person who is the subject of the appeal, and in the case of a matter that is conducted before a panel of 3 members, written submission written submission for the representation or agent of United Nations High Commissioners of Refugees and any other persons described in the rules of the board. Time limits. Subparagraph 3.1. Unless a hearing is held under subsection 6, the Refugee Appeal Division must make a decision within the time limits set out in the regulations. Evidence that may be presented. Subparagraph 4. On appeal, the person who is the subject of the appeal may present only evidence that arose after the rejection of their claim or that was not reasonably available, or that the person could not reasonably have had accepted in the circumstances to the presented at the time of the rejection. Exception. Subparagraph 5. Subsection 4 does not apply in rejection of evidence that is presented in respects of evidence presented by the minister. Hearing. Subparagraph 6. The Refugee Appeal Division may hold a hearing if, in its opinion, there is documentary evidence referring to in subsection 3a that arises a serious issue with respects to the credibility of the person who is subject of the appeal. B, that is certain to the decision with respects of the refugee protection claim, and C, that is accepted would justify allowing or rejecting the refugee protection claim. Decision. Paragraph 111, subparagraph 1. After considering the appeal, the Refugee Division shall make one of the following decisions. A, confirm the determination of the Refugee Protection Division. B, set aside the determination and substitute a determination that, in its opinion, should have been made. Or C, refer that matter to a Refugee Protection Division for redetermination. Give the directions to the Refugee Protection Division that it considers appropriate. Referral. Subparagraph 2. The Refugee Appeal Division may make a referral described in paragraph 1c only if it is on the opinion that A, a decision of the Refugee Protection Division is wrong in law, in fact, or in mixed law and fact, and B, it cannot make a decision under paragraph 11.1a or b without hearing evidence that was presented to the Refugee Protection Division. All right, my friends, I'm going to end this part here today. And after I post it, I will make the second half and get that up to you. So keep watching.